Good morning, everyone. This is Sarah Willey. I am joined here today with my fearless colleague, Sandy Andre, and welcome everyone, and thanks for joining us. I assume most of our audience today, Sandy, is joining us because they heard the news, and that is that yesterday, MIOSHA rescinded its existing emergency rules, implemented the MIOSHA emergency temporary standard that applies to healthcare organizations, and otherwise referred all other employers to the current CDC and OSHA guidance. And so that has just raised lots of questions. I'm getting lots of questions from clients, of course, lots of folks wanting to confirm that it's true that the MIOSHA emergency rules have largely gone away and need to understand what their current obligations are. So Sandy and I are here today to talk to you all about that and to answer all of your questions as best we can, okay? Sandy's going to dig into it pretty deeply, but I just want to give you first kind of a broad roadmap, okay, so that we can give context and sort of frame our thinking here. The MIOSHA emergency rules as we knew them, okay, as have existed since last October, are no longer in place. So that means there are a whole lot of things that employers are no longer specifically required to do. At the same time, before we all get really excited, there are some things that are still required and are still in place. And the two most important things that businesses need to remember are, number one, that Public Act 238. That's that Michigan law that provides attendance protection for employees who have been exposed to COVID-19 and are unvaccinated, as well as employees who have tested positive or have symptoms of COVID-19, okay? That's the first thing. And then the second biggest piece that employers need to remember is OSHA still has what it calls the general duty clause, which means every employer has a general duty to provide a workplace free of known hazards. And so long as we're still living in the time of a global pandemic, OSHA and MIOSHA are going to be expecting employers to take precautionary measures, right, to protect their employees from COVID-19. What those look like for your particular workplace now is dependent upon your own decision making, however, okay? That's both wonderful and terrible all at the same time. And then there are a few additional OSHA and MIOSHA standards that are hanging out there that you all need to understand and remember too. But that is the big picture, okay, to sort of set the roadmap for the webinar today. So with that, Sandy, I'm going to let you take it away, and then I'm going to watch the questions and also answer questions as we go, okay?
Excellent. Thanks, Sarah. Good morning, everybody. Yeah, as Sarah mentioned, an exciting, both exciting and terrifying new world that we are in. But as Sarah mentioned, we will talk about the pieces that are no longer required from a workplace safety standpoint. We'll talk about the pieces, the details on what is still required, and then we will talk a little bit about what new requirements there are. And so let's go ahead and get to it. So if you are like me, maybe this is how you felt yesterday, that the thought that the MIOSHA COVID-19 emergency rules that we have been living with since last October, and really longer than that, because many of those rules previously lived in executive orders, for over a year now. The news that those were rescinded and were no longer applicable made us all think, is this real life? Right? We kind of felt like Daniel coming back from the dentist. But we need to channel our inner Han Solo here and go forth, right? It's true. All of it's true. So let's go through the pieces, the no longer required MIOSHA COVID-19 emergency rule. So effective yesterday, it was immediately effective, that rescission. The October 2020 MIOSHA COVID-19 emergency rule was rescinded. So this means that employers in Michigan are no longer legally required to maintain COVID-19 preparedness plans. I should say no longer legally required by this rule to maintain COVID-19 preparedness plans, basic infection prevention measures for all employers, such as providing hand sanitizer, those pieces. No longer required to complete health surveillance for all employees, right? So the daily entry screening where we're asking about if someone has tested positive, if they're experiencing symptoms, if they've had close contact, that screening process is no longer required by MIOSHA. Various workplace controls that employers were required to have in place. The big piece here, of course, was masking and distancing requirements for your unvaccinated staff. That requirement goes away. The training requirements that you previously had for all employers, where you were required to train your employees on your workplace infection control practices, proper use of PPE, the steps employees must take to notify your business of suspected or confirmed diagnosis, how to report unsafe working conditions, also no longer required, and your record-keeping requirements. So you may remember, right, you have the daily entry health screening, the training pieces, and the notifications you were required to do after you learned of a positive case in your workplace. Those all had notification requirements, and you had to retain those records for 6 months. That requirement has also gone away. But as Sarah mentioned at the beginning, as we were kind of setting the stage here, that, you know, we're not going to take everything we've done in the last 15 months and, you know, put it in the bonfire today. We do have to make sure we understand well the mitigation requirements that still apply, that lived outside of that COVID-19 emergency rule, either within OSHA or another government entity, to make sure that we still have the protocols in place to be compliant with those obligations. So the first place we'll start, as Sarah mentioned, is the COVID-19 Employment Rights Act, and this was previously called Public Act 238, went into effect last October, became retroactive to March 1st, 2020, and importantly, it does not have a sunset. So the rescission of the MIOSHA rule, the rescission of the DHHS orders, those pieces, the COVID-19 Employment Rights Act is not dependent on either of those orders, so this remains in place. It was amended in December, which was good news because it was amended to generally match the CDC recommendations related to isolation and quarantine. So you may remember, as Sarah mentioned, attendance protections for your employees, right? Your employees have an obligation not to come to work if they have tested positive and they're still within the isolation period, if they're experiencing symptoms and they're still within the isolation period and haven't received a negative test, or if they have had close contact with an individual and they're still within a quarantine period. Now remember, there are exceptions to that close contact quarantine. There are certain types of jobs, like healthcare employees, for example, that are exempt from that close contact quarantine requirement in the COVID-19 ERA, but also fully vaccinated individuals are exempt from the close contact quarantine period as long as they are asymptomatic as well. So it's important for you as an organization to understand your employees' own obligations to stay out of the workplace under those circumstances. But you also need to understand that you must refrain from counting attendance, absences towards disciplinary action when you have an individual who is gone from work for one of those reasons, okay? So that's the first piece that we'll keep our eye on and remains important. The next piece, let's talk about, you may remember way a long time ago when we first started talking about this before we had a MIOSHA emergency rule here in Michigan. We were trying to figure out what do employers need to do. And the first place we started was, well, what existing standards are in play that may apply to the COVID-19 situation? And those standards remain. As we sit here today, 15 months later, these are all existing standards that were on the scene well before COVID-19 and remain on the scene, and we need to continue to be compliant with those. The PPE standard, sanitization standard, respiratory protection standard, hazard communication, access to employee exposure and medical records, and recording and reporting of occupational injuries and illnesses. Now, many employers, these standards aren't in your day-to-day lives, right? Depending on the type of organization you are, you may have no reason to ever pay attention to the respiratory protection standard as an example. So for the majority, right, depending on the type of organization you are, some of these may not impact your day-to-day life. The one piece that remains important, of course, is recording and reporting occupational injuries and illnesses. We still have to do, if we become aware of a positive case in our workplace, we have to undergo that work-relatedness analysis, right? And if we determine that our employee's COVID-19 positive is work-related, we have obligations to record that illness on our annual logs and injury reporting. And if we have an individual who's COVID positive results in hospitalization or death, we have obligations for reporting that information in a timely fashion to MIOSHA as well. So those pieces have not gone away. Now let's talk about where things, the big picture, but where things are a little bit more gray or hard to understand exactly what our obligation is. As Sarah mentioned, Michigan employers and even employers in other states that don't have a federal OSHA approved state plan have obligations under what is called the General Duty Clause. And under the General Duty Clause, employers have an obligation to furnish each employee employment and a place of employment that is free from recognized hazards that are causing or are likely to cause death or serious physical harm to employees. So that's a pretty broad piece, right? We're used to saying, okay, I have to do these 20 things. And as long as I'm doing these 20 things in the COVID-19 emergency rule, I'm in good shape. Now we get back to having just this overarching responsibility to provide a safe workplace for our employees, but we don't necessarily have the specifics on how to do that. So far, what MIOSHA has said to us about the General Duty Clause during the COVID pandemic is contained in their most recent enforcement guidance, which was updated in March. So a little old, but that's what we have. There they have said that when they're determining if there is sufficient evidence for a General Duty Clause citation, the employer's COVID-19 program in its entirety will be evaluated. And if after consideration considering all of the measures the employer has implemented, if there still exists a recognized hazard, a general duty clause citation may be warranted. So it's kind of this totality of the circumstances, which means that it's going to be an individualized assessment to your workplace, right? So the point here is, as Sarah mentioned, your organization is going to have to determine what it needs to do to, in good faith, keep COVID-19 out of your workplace and prevent the spread in the workplace. With the press release with the MIOSHA rule, the general MIOSHA rule rescission yesterday, MIOSHA said that their expectation is employers are using their best judgment in determining what mitigation strategies to maintain. So a couple of slides ago, we talked about, right, the MIOSHA COVID-19 emergency rule that went away, and we're no longer required to do this, that, and the other. But in your organization's individualized assessment, you may determine that some or all of those mitigation strategies remain, continue to make sense for your workplace, okay? So again, an individualized assessment for your organization. So the good news to say, okay, well, that's great, Sarah and Sandy, but I don't even know where to start. How do I keep COVID-19 out of our workplace and prevent the spread? Well, the good news, I guess, about being 15 plus months into a pandemic is that we're all 15 plus months into a pandemic, right? We are not without tools to understand a little bit about COVID-19 and how it spreads and how to reduce its spread in our workplace, right? We're not in the same place in understanding those pieces as we were back in March and April of 2020. We have assembled many tools for our tool belt here, and we can rely upon those. And we have information to understand the risks specific to our individual workplaces too, right? We have had 15 months of experience where we have a general understanding of the spread in our facilities. Maybe we have an understanding of the vaccination rate among our employees. We understand and have data related to the spread in the community where we have facilities, and we understand the type of work that's happening in our facilities that may present a potential hazard, right? If we have employees who are entirely remote, well, there's not much likelihood that COVID is going to come into and spread in your workplace, right? But if we've got, 500 employees in a shop floor and everybody's within 6 feet, we understand that there's some risk there. And so we need to dig in and find out what makes sense, what mitigation strategies make sense for our workplace. So where do we start? I talked about some of the tools we have to make those determinations. Let's go ahead and go through them. I want to be really clear that when we're talking about what is required, what is required is compliance with the MIOSHA General Duty Clause, and we are not saying it's required that you follow every single recommendation from the CDC and every single recommendation from OSHA, right? The guidance documents from the CDC and the guidance documents from MIOSHA are tools for your toolkit, right? That give you some information to help you understand COVID and understand its particular risk to the type of work you do, the type of facility that you have. And those just become resources to you so that your organization can make that individualized assessment, okay? So by now, I suspect that everybody on this call might have this page bookmarked in their browser, right? The workplaces and businesses page on the CDC's COVID-19 page, right? They've got workplace guidelines, general business information, but they also have some industry-specific information as well. So that is a fantastic resource. I've got the screenshot here as well as the link to the site so that you can bookmark that if you don't, okay? Next, we have a document that probably looks familiar to you. a joint issued document at the beginning of the pandemic here from OSHA and the CDC called Guidance on Preparing Workplaces for COVID-19. Now, for employers here in Michigan, we know this document well because our previously required COVID-19 preparedness and response plans needed to be based generally upon the recommendations contained in this document. So I still like this document. It has now become an archived document, to note, but it is a good layout for those who want to continue to have some sort of COVID-19 preparedness plan, the different things and the way that you can structure that and think about it, okay? But the big news over the last couple weeks is that OSHA, federal OSHA, has updated their recommendations for workplaces related to COVID, and they maintain this on their website. Again, these are recommendations. No employer is required to do all of these things, but to the extent that we understand what federal OSHA is saying are the considerations employers should be making or should think about making, or some ideas for mitigation, some ideas to abate known hazards, it's important for us to consider those and make a determination of whether that recommendation makes sense for our workplace, okay? So this guidance was first issued in January of 2021, and it was revised just a couple of weeks ago. And OSHA's guidance has transitioned, right, as vaccination has become available and prevalent, to really wanting to focus protecting unvaccinated and even vaccinated but still at-risk workers in their workplaces, and has provided some strategy recommendations on how you might do that. So as you look at this list, Michigan employers, we previously didn't pay too much attention to this list because all of these things, almost all of them, were requirements that lived in our MIOSHA COVID-19 emergency rule or lived within the COVID-19 Employment Rights Act, or any other general set of standards that already applied to us. But now that MIOSHA emergency rule has gone away, being for most businesses, we look at some of these pieces anew, right? So paid time off for vaccination, implementing physical distancing for unvaccinated and at-risk employees, conducting COVID-19 education and training, maintaining ventilation systems to ensure airflow, recording and reporting COVID-19 infections and deaths, which we know we already have an obligation to do under existing MIOSHA standards, following other applicable mandatory OSHA standards, which here in Michigan, MIOSHA has adopted, continuing with CDC recommended isolation and quarantine protocols. Again, here in Michigan, we have a separate obligation to do that already through the COVID-19 Employment Rights Act, considering recommending face coverings for unvaccinated and at-risk employees, suggesting that unvaccinated customers and visitors wear face coverings when in the facility, performing routine cleaning and disinfection, and creating some kind of mechanism for staff to report unsafe working conditions. So again, this list here are simply OSHA guidance recommendations, nothing any Michigan employer is necessarily required to do, but abatement ideas that will help inform the individual pieces your organization will do to comply with MIOSHA's general duty clause. That said, there is also a new requirement, and I hope that no one on the call is about to panic. So the new requirement in the press release yesterday, MIOSHA announced it was rescinding the October 2020 emergency rule, but it was issuing a new emergency rule that would be effective until December of 2021. And the good news is that this new emergency rule mirrors exactly a recently announced federal OSHA emergency temporary standard that applies only to certain healthcare facilities. And Sarah and I have kind of joked that we could talk for an hour just talking about who this standard applies to. So rather than trying to even give it any justice here during this webinar, we are going to dedicate an entire webinar to talking about this emergency temporary standard for healthcare settings, and we will be doing that next Tuesday. Now, the standard itself does not become effective until July 5th, 14 days from when the temporary standard was announced in the Federal Register, and it was announced in the Federal Register on Monday, June 21st. So we've got a 14-day runway, so not to panic that we're not having a webinar about it until Tuesday, but that is where we will go through this temporary standard in its entirety. So as we've gotten to this place, you might be here, right, thinking, okay, what is it then that I need to do today? As I get off this call and I make my list of things, this is the checklist we want you to go through, okay? We want you to understand that you need to maintain compliance with Michigan's COVID-19 Employment Rights Act isolation and quarantine protocols. So you need to maintain compliance with that, and you need to keep your internal protocols that allow you to monitor that, to do those things. So we need to understand, second, then, that we need to maintain compliance with MIOSHA's existing standards. Again, that's going to impact each of our organizations very differently. It's going to depend on the type of work that we're doing. But something that's broadly applicable to all of us of those standards, right, are the reporting and recording requirements related to cases of COVID-19 in our workplace, that we must continue to do that work-relatedness analysis. The next piece then, maintain compliance with MIOSHA's general duty clause. And the big question there is, what does our organization need to do to, in good faith, keep COVID-19 out of our workplace and prevent the spread in our workplace? So we have provided some resources for you to understand what the CDC is saying that workplaces can do. There are strategies, mitigation strategies workplaces can implement to help with that, what OSHA, federal OSHA has said on that standpoint, and then you all need to do an individualized assessment based on the information that's specific to your workplace. The big piece here, right, is being responsive to your organization, your facilities' specific circumstances based on what's happening in your facility in terms of the work, the vaccination rate, the spread, what's happening in your community, and being responsive to those things. It's those individual decisions for the organization to make to understand how you plan to keep COVID-19 out of and prevent the spread in your workplace. And then finally, over the next couple days, it'll be important for you to understand whether the federal emergency temporary standard applies to your facility or any portions of your facility, so that you can plan on how you are going to be compliant with that standard that takes effect in early July. Okay? Okay, with that, Sarah, let's head to some questions.
Yeah, thank you, Sandy. That was very, very helpful, and I appreciate that. I'm going to start kind of with where you left off, and that is I'm getting a lot of questions from folks who really want to know what they should do, right? Should we continue with the daily health assessments? Should we require masks? Should we do the training, et cetera? And I just want to reemphasize what Sandy's saying, and that is it's difficult for us to answer that question specifically in this webinar, because the answer really depends on your organization and your facility, okay? Compliance with the general duty clause is going to look very different in an office setting than it does in a food processing plant, for example, right? It's going to depend on the amount of close contact between employees. It probably is going to depend on the level of spread and the vaccination rate in the community in which you're located, okay? So some of these decisions are really going to have to be made on an individual organizational basis, okay? So with that said, I do want to suggest a couple of things that just about every workplace, I think, should continue to do to comply with its general duty to provide a safe workplace to their employees. And that is number one. I'm getting a lot of questions about the COVID-19 preparedness plan, right? Should I just throw it away? Should I have a bonfire this weekend, right? What should I do with that plan? If you are an employer that has already put the work into a COVID-19 preparedness plan, I don't see any downside to keeping that plan, right? Why would we not want to have that plan in a drawer in the hopefully unlikely chance that we could have a future COVID-19 outbreak either in the community or in your facility, okay? And if there was a concern, if you ever did have to show OSHA what efforts you made to provide a safe workplace, I think you're probably going to want to say you had a plan in place. Okay, so that's on the list of things I think would show a minimal effort, and I would encourage most employers to do it. Also on that list, and this ties to Public Act 238, the COVID-19 Employment Rights Act, I would continue to in some way communicate to employees that if they've tested positive for COVID-19, if they have principal symptoms of COVID-19, or if they are unvaccinated and have had close contact, they're not supposed to be coming to work. I don't think you necessarily have to do that formal daily health screening anymore, but that expectation should remain in place. And I think you probably want to be able to say that you told your employees that expectation is in place. So those are the two big ones. Of course, Sandy, I'm getting a lot of questions about masks, right? Should I continue to require masks or not? And I think that falls into the category of questions that we would really need to know more about your workplace in order to tell you whether you should continue to require unvaccinated employees to wear masks indoors, okay? I will say I would tend to suggest that only if it's a workplace in which it's very, very difficult to distance your employees. They have regular and sort of uncontrollable close contact with each other all day, every day. And there are ongoing concerns about the spread of COVID where you are. I'll also add that with regard to masks, you may be a workplace in which you don't always require unvaccinated employees to wear masks indoors, but if you have an outbreak, you might, right? So you might have to adjust your approach to masks depending on what's happening. If you know COVID-19 is present in your workplace, you had an employee test positive, you know they were in close contact with other unvaccinated employees, you may, for 14 days or so, say to everybody, look, all unvaccinated employees now have to wear masks, okay? These are just ideas for how to approach that general duty clause. Okay, I'm going to take a deep breath there, Sandy, and ask if there's anything you would add to that.
No, I think that's exactly right. And I think that theme you hit on at the end is a really important piece for people to keep in mind, right? It's responding, right? We've kind of shifted. Instead of doing all of these things, whether we think they make any sense for our workplace or not, it's now being responsive to the unique circumstances of our workplace. And those unique circumstances can change, right? And we need to be responsive when circumstances warrant that. So the example that Sarah just gave is exactly right? Maybe today we make the decision that no, we don't need to have unvaccinated staff continue to wear masks indoors, but there are circumstances that could change that. So kind of looking at it like what Michigan broadly has been doing all pandemic long, right? I know the governor has often used kind of the analogy of it's not a light switch, it's a dial that can turn up and turn down, right? We need to be responsive to what's happening, and that's the approach that makes a lot of sense for employers to start to think about and understand that your approaches here will need to be flexible. The decisions you make today about what mitigation strategies remain might not make sense a month from now, and might not make sense, right? And any changes you make then might not make sense a month from then. So understanding the circumstances in your organization and making your decisions based on those is what is really important.
Right. And I think there's a question regarding contact tracing, Sandy, and I know I have thoughts on that. But if we had an employer that had an employee test positive for COVID-19, okay, and that employee had been present in the workplace in the 48 hours before the employee began experiencing symptoms.
Yep.
Would OSHA's general duty clause likely expect that employer to do some contact tracing in that workplace? What are your thoughts on that?
Yeah, I would say yes in a couple of different ways. One, right, we have the recording and reporting standard that requires us to do a work-relatedness analysis of that individual's positive case. So we need to understand, right, so that's the first piece. And so in doing that, we're necessarily going to need to know who, right? Where has that employee been in our facility? Who have they been around? So that's the first piece, that some contact tracing, right? But the second piece falls right within the general duty clause. We have an obligation to prevent the spread in our workplace and keep COVID out. So to the extent that now we have an employee who has tested positive, we, right, have an obligation to try to minimize the spread based on that individual's presence in our workplace. And that's necessarily going to involve, right, figuring out where they've been in our facility, who they have been around, all of those pieces. But also understanding, right, if you've got an employee that comes forward and says, hey, I'm unvaccinated and I was a close contact of this person who's just tested positive, and so I'm going to be out, right, for a quarantine period, we need to understand the details surrounding that so that we can be sure not to take, attendance action against that person, as an example. So I see a couple of different obligations to engage in some information gathering, right? Whether we call that contact tracing, and we continue to, turn over every leaf to the extent that we have in the past, maybe that doesn't make sense. But we do still have some obligations to respond to information that is in front of us and ask some questions.
Excellent, excellent. I'm going to pivot for a minute because we have some other more general questions about Public Act 238 and a few other things that I do want to answer before we finish. Okay, so the first one is kind of a fun one, and that is, do we think Public Act 238 is ever going away? Okay, and just a reminder, when we talk about Public Act 238, we're referring, it's also called that COVID-19 Employment Rights Act. That's that law in Michigan that provides attendance protection for employees who are missing work for certain COVID-19 related reasons, okay? So my first response is, well, understand, in order for that to go away, it requires an act of our Michigan legislature that then is signed by our governor. Okay, so it's a much more complicated process than the Department of Health or MIOSHA just issuing something saying we are rescinding it. Okay. And the law and the law itself does not have an automatic sunset. Okay. Now, I'm not entirely pessimistic about it. I think if we reach a point at which COVID-19 is no longer a pandemic in our community and businesses are expressing concerns and experiencing issues, because it's still required to provide attendance protection anytime somebody has symptoms of an illness that is no longer a problem in our community, then I think it's entirely possible that our legislature and governor could work together to rescind it. I don't think that's going to happen, however, likely for at least several months. So I would encourage our listeners to just plan on complying with it and sticking with it for a bit of time. And of course, we will update you guys as soon as we hear anything more about that. Next question, can local counties have their own requirements? And the answer to that is absolutely yes, sure. And we saw that back at the beginning of the pandemic. As Sandy likes to say, everything that's old is now new, right, Sandy? And so back at the beginning of this thing, we had local health department, at the Michigan Department of Health hadn't yet issued any emergency orders. And so our local health departments were making the rules. It's possible local health departments might do that again. That's not something that we are seeing as likely. But if they do, those health departments do have the authority to do that.
Yep, and I'll just interject and say, since we've had the broader MDHHS orders and the Michigan MIOSHA COVID-19 emergency rule, generally we've seen local health orders that come on the scene being responsive to an event, right, or an an outbreak, so to speak, right? We saw them kind of in the fall, maybe in communities around college campuses, as an example, responding to outbreaks in those locations. So that's generally what we have seen. But I echo exactly what Sarah says, right? We've kind of been on a wave, right? When state orders have lessened and have been quiet, sometimes we see local orders ramp up. But the idea behind that is, right, that they're responding to the situation in the local community. So that makes a lot of sense. So still makes sense for you to bookmark your local public health department's page, get on their listserv so that you can understand what orders might be in place right now and what may come down.
Right. Okay, now we have a host of questions, Sandy, that relate to keeping records. Okay. So just to sort of retrace our steps for a minute, we had MIOSHA emergency rules that have all along required employers to keep certain records. Under the first set of emergency rules, it said we were supposed to keep those things for a year. Then that changed, and it slightly changed what we had to keep and also shortened the time period to 6 months. Now the emergency rules have been completely rescinded. And so naturally we're getting listeners saying, well, what in the world is the rule now in terms of keeping those records? And I think probably we need to answer this more from a practical standpoint. Yes. Because to be quite honest, it's not entirely clear what the record keeping requirement is right now. because the emergency rules have been rescinded, yet there was a record keeping requirement that extended 12 months and then 6 months, right? And so what I would say is, you all want to be in a position for a host of reasons. Okay, there's certain immunities that are potentially available, et cetera. You want to be in a position to be able to show that you are complying with the emergency rules that were in place at the time, and you were showing good faith to protect the safety of your employees. My practical advice would be to continue to keep the records you have for 6 months. But I'm going to invite Sandy to disagree with me or share another perspective on that if you have one, Sandy.
Nope, I totally agree with that. And I echo Sarah's practical advice, right? She and I are living our best life when our clients, right, when they get contact from a government agency or a complaint, and they're able to say, you know, whatever the complaint is, to say, oh no, here's how we were complying, and here's our records that we had in place at the time, right? We know that MIOSHA complaints, right, don't necessarily happen in real time, right? If you've got an employee who makes a complaint today, you're probably not going to get a phone call from MIOSHA today saying, hey, show me how you've been compliant. So it makes practical sense for you to position yourself to be able to show that you were compliant with the requirements in place at the time. And because we previously had a 6-month rule, that makes a lot of sense to me. So I totally agree.
Okay. And just a reminder, employers can choose to continue to require their unvaccinated employees to wear masks indoors. That is a business decision that an employer could make. Absolutely. We are still in a global pandemic. We may come to a time in which I will tell you, you can't do that anymore, or that's not a good idea to do anymore. We haven't reached that time period though yet. Okay, I just want to finish with some questions that relate to Public Act 238, okay? And the first thing I want to say is, and Sandy mentioned this before as well, the quarantine and isolation requirements under Public Act 238 now tie to the CDC guidance, okay? And we've all been doing this for long enough to know CDC guidance changes. It continues to evolve, okay? So we can answer these questions based on CDC guidance as they exist today, but that's going to change almost certainly, okay? So first, relates to close contact with somebody who has a known case of COVID-19, okay? The requirement to quarantine after close contact now only applies to unvaccinated employees. If an employee is fully vaccinated, they do not have to quarantine after close contact, and Public Act 238 does not provide them attendance protection for that quarantine period. There is a small exception if they are particularly at risk, and so a healthcare provider said, for some reason you still should quarantine, then that could be different. But that is going to be a very, very unusual circumstance. Sandy, I got a great question, and actually it's funny because this occurred to me last night as well. You know how Public Act 238 says we know what the principal symptoms of COVID-19 are based on how the Michigan Department of Health defines them? Mm-hmm. What in the world are we supposed to do now that the Michigan Department of Health order defining them is gone? Mm-hmm.
Remember how happy we were that when it finally linked back to the MDHHS order? We were so naive.
Yeah, that is so thank you for that question. And I did recognize that last night as I was digging into this too. And guess what? I had the same question and I don't have a firm answer for you. I guess I have a practical answer, which is I think we define them as best we can based on what the last MDHHS order said. From a practical standpoint, that's probably what I would tell a client to do. If something monumental changes with regard to those symptoms and how the CDC defines them, we'd probably pivot and apply that new definition. Okay, but this really, we are working in a space in that case of doing the best we can, of acting in good faith based on what we have in front of us. That's a problem that I think just hasn't been recognized.
Yep, agree.
Okay, and again, I just want to clarify, I got a question. If we aren't subject to that OSHA emergency temporary standard that applies to healthcare organizations, do we fall into the general duty clause and Public Act 238? And the answer to that is a resounding yes. That is the point, okay? Every employer in Michigan right now is subject to Public Act 238 unless there are exemptions in that law for certain employers, okay? But Public Act 238 still exists, and if you are subject to it, you still have to comply with it. And the general duty clause also applies to everyone. Okay. Anything else, Sandy, that you see needs to be answered? I think we've covered all of the patterns of questions that I see.
Yep, I agree with that. I see, lots of questions. Should my organization continue to do this or that? And again, as Sarah mentioned, that's going to be very specific to your organization and your facility. And without some of those details, it's hard for us to broadly answer. But we've given you some tools and some things to think about as you consider what of those previous must-dos now continue to be continue-to-dos at our choice.
Exactly. Okay. Well, with that, I'm going to thank everyone for joining us and remind you all that if your organization provides any sort of healthcare services, and that can include, by the way, a nurse or a OC health clinic in a manufacturing facility, for example, then you're going to want to tune in to our webinar next Tuesday, in which we are going to go through in detail that new OSHA emergency temporary standard. With that, thank you everyone for joining us, and thank you, Sandy, as always, for your insight and expertise. Bye-bye.
Excellent. Thanks, Sarah. Thanks, everybody. Bye-bye.